Hello, everyone, and welcome to our 2023 Community Association Legislative Update. My name is Miranda Ward, one of your Client Relation Directors with Davis-Stirling. We are thrilled to see so many of you today. We have a lot of information to cover, so we're going to get started. Before we begin, this meeting is being recorded. If you require closed captioning, please request it at the bottom of the screen. Please make sure to rename yourself via the participants list to your first and last name for attendance. We will be taking new legislation questions via the chat or Q&A function to be discussed at the end of the program. We are about to launch a poll. Please make sure to answer so we have an idea who is here today. Wonderful, thank you all. All the information covered in the webinar today will be covered on our website, Davis-Stirling.com. Now, on to the presentation. Please welcome founder and co-managing partner, Adrian Adams, co-managing partner, Laurie Poole, partner Jason Savlov, partner Melissa Ward, and senior attorney Alison Greiner.
Thank you, everyone, for attending. We'll wait another minute or so. I see a lot of people are still logging on. But just to let you know, on the questions, you'll be submitting them, as Miranda said, through your chat. And I suspect we may get more questions than we could answer at the end. And if we do, what we'll do, I'll answer them in a newsletter. And I think, Miranda, you'll probably remind everybody at the end. So we'll try and get to as many as we can. There's a lot of legislation, some of it good, some of it scary, and we'll cover it as we go through. So who has the first slide? Let's go ahead and advance it.
Okay, so this is me, and I'm Alison Greiner. And this is one of those the good legislation that Adrian mentioned. This is one we like. This is AB 648. It's virtual meetings. So the intent here of the legislature was to clean up some of the current laws on virtual meetings. The reason is because virtual meetings are good for everybody, and they're admitting that. It improves homeowners and board members' ability to attend and to participate in meetings. So this bill is adding Civil Code Section 4926, and some of the important takeaways here. Well, the first thing is it only applies to open session board meetings and membership meetings. So this doesn't apply to executive session board meetings. So this allows virtual meetings to be held with no physical location required. So that's allowed as long as certain things are met. The first being that the meeting notice must contain clear technical instructions on how to participate virtually. Technical assistance must be provided. So that would need to be in the meeting notice as well. It would be a phone number and an email of a person that can assist both before and during the meeting. And that could be a board member or a manager or somebody from the management company, but just somebody that's able to assist with logging in to the meeting. There must be a phone option provided. So in addition to the virtual option, you must also provide a way for somebody to just call in and participate. The meeting notice also has to contain a reminder to members that they can request individual delivery of meeting notices. And then finally, the directors have to vote by roll call. And so that would be who's attending, who is voting, and how they're voting. And that should also be recorded in the minutes of the meeting. And then finally, this does not apply to meetings where ballots are counted. So ballot counting meetings, you still have to provide a physical location. However, we believe that if you can advance it to the next slide, I think there's more information on the next slide. So ballot counting meetings, you still have to provide a physical location. But we believe that the inspector of elections can still be remote. So that's not clear in the law or in the bill. So the way that we're interpreting it is that the inspector can still appear remotely. So that's about it with AB 648.
And I just want to add, you mentioned that it doesn't apply to, it applies to open board meetings and membership meetings. That's correct. And that the reason is for executive sessions didn't have the requirement for the physical location. So I want to be clear that everybody understands you can have executive session meetings virtually, solely virtually without a physical location. That was already existing in the law.
Yeah, let's go to the next slide. Rachel, the next slide. There we go.
Hey,
Quorum.
this is me, Melissa Ward. Hello, everybody. Welcome. I have AB 1458, which is regarding quorum. Now, quorum is more than just a good Scrabble word. It's the number of votes that you need, whether it's people or ballots, to conduct business or to have a valid election. And this new legislation allows for reduced quorum if you don't get enough people to have your quorum, if you don't get enough ballots returned. So if, for example, if you had if you only got a certain number of ballots returned and you weren't able to do that, you can adjourn the meeting, and that the number of ballots that you will need is reduced to 20%. And you have to adjourn that meeting for at least 20 days. Additionally, that 30-day pre-ballot notice that we have to do now, you have to list the quorum requirement in that notice as well. So if your bylaws already provide for a reduced quorum, then this statute doesn't really apply. It's kind of a stopgap if you don't have a reduced quorum requirement to help our associations conduct their business more easily. And the most important thing about this is that it does not apply to recall elections. So it applies to all our other kind of elections and meetings, but not to recall elections.
Okay, let's go to the next slide. Yeah, this is helpful for associations that don't have the reduced quorum and really need it. And believe it or not, some associations, 20% is still too high. But this at least will help many associations. Okay, this is AB 1764 dealing with elections, and it requires that you disqualify candidates, who serve a maximum term. So if they're termed out, they have to step down, and it requires it. So previously it said may, and now it's just required that they step down. All right, this can be a problem for associations that have strict term limits, meaning that they serve 2 terms and then they're required to step down. We write our bylaws and election rules so that they're termed out after 2 terms and they step down unless nobody else is running, because you don't want to force people out of office if no one else is willing to step in. So our recommendation is you amend your election rules and bylaws to, if you have a strict rule on term limits, so that you make it more flexible if no one else is willing to run. And then secondly, this requires that if you disqualify a nominee, that the directors must comply with the same requirements. And that, at first you might think, okay, so if you require that co-owners of a unit cannot serve on the board at the same time, and you just amended your election rules to say that, and you've got 2 co-owners on the board, one of them has to step down. We don't think so. They serve out their terms. It's when they come up for election that then they would have, one of them would have to not run, or, so that you can't have 2 co-owners on the board at the same time. Okay, let's go to the next slide.
Okay, so this is AB 1033, and you may also see a very similar bill, AB 976, that had the same language. AB 1033, they were both enacted the same day, but AB 1033 was chaptered, 1 chapter after 976, so that one's the operative chapter. So this bill does not amend directly the Davis-Stirling Act, but it amends Government Code Section 65852.2, which is the Government Code section that allows cities and counties, or actually mandates that cities and counties make it easier for owners of property to build accessory dwelling units. So that's the ADU law. And currently, prior to January 1 of 2024, people who build ADUs on their lots are very limited in being able to sell those ADUs to other people. However, that's what this bill did. So AB 1033 has now allows cities and counties to have an ordinance into their ADU ordinance that will allow for owners of property who build ADUs to be able to separately sell that ADU as a condominium. So the bill requires that the ADU will have to be set up as a condominium. It will have to comply with the Davis-Stirling Act. They will have to get approval of their mortgage holders. There's a lot of requirements for these owners to be able to sell their ADUs as condos. But how that affects homeowners associations, HOAs, existing HOAs, is that the bill says that an owner of a separate interest in a planned development is not going to be authorized to record a condominium plan for an ADU without getting express written authorization by the existing association. So if you're a planned development association and you have owners that are going to want to build ADUs and sell those ADUs as condos, they're going to have to get approval of your association in order to do that. Now, how that's done, the statute says that the written authorization by the association can either be the board or it can be by a membership approval if the governing documents require a membership approval. So the takeaway on this bill is that you need to be consulting with your legal counsel to determine whether you need to amend your governing documents to require a membership vote to allow another member to be able to build an ADU and sell it as a condominium. The bill also deleted a requirement or deleted the ability of cities and counties to require that either the ADU or the primary dwelling be occupied by the owner of the property. That was allowed. It would have been allowed after January 1st of 2025 that cities and counties could require this owner occupancy, but they took that out of the bill. So cities and counties now cannot have that as a requirement, but we think that HOAs, associations, would still be able to have that owner occupancy requirement. But again, consult with legal counsel.
Yeah, I think it's important for associations to know. First of all, this applies only, to planned developments. So you've got a lot, you can build an ADU on the lot, and then you convert it to a condo with board approval. Well, I think we want to eliminate boards approving these things. This is going to create a nightmare. If it's a renter in there, that's one thing, and they're not a member of the association. But once they become an owner, does that mean they automatically become a member of the association? Do they get voting rights? I think it's going to create a lot of problems if planned development start allowing ADUs to be converted into condos. So we're recommending that you amend your documents to say that any conversion or request for conversion has to be approved by the membership. And I would make it at least 50% of the members who are going to have to approve this.
Yeah, and I also think
really
we
don't want these to occur.
Sorry.
Go ahead.
I also think that when we're amending the documents too, I think we would clarify that the lot owner is still the owner, that these ADU condo owners are not going to be considered owners of the association, but they will be occupants and they will be bound by the governing documents as an occupant, but not an owner.
Yeah, I agree. Okay, let's go to the next slide.
Okay, AB 572. This amends Civil Code 5605, which is the statute that requires the membership vote for over 20% for regular assessments and 5% for special assessments. So for original CC&Rs recorded on or after January 1, 2025, the board cannot impose a regular assessment against an owner that has a deed restricted for affordable housing. that is more than 5% plus the percentage of cost of living, and it's not to exceed 10% greater than the preceding regular assessment. This does not apply to HOAs with 20 units or less, and there are also some certain exceptions with zoning ordinances. And
Okay,
that's
I think there's
AB
another slide.
572.
Yeah, do we have another slide? The next one also covers some of this. Rachel, if you could advance it. No, okay, let's go back. On these assessment limitations, I think are going to be really problematic moving forward. In the long term, it's going to create some real difficulties with associations. They're starting to force, low income owners into associations that have maybe much higher income owners in them. And so what it means is there's going to be a disparity that's going to grow over time as assessments increase, which means that the rest of the owners are going to be basically subsidizing the low income owners when it comes to maintenance and reserves for their common area amenities. So, and I think, Laurie, did you want to say something about that? No?
What did I want to say, Adrian?
I thought you had something on that. Okay, so I don't think that's going to have much impact right now on anybody, but certainly moving forward, it will. So let's go to the next slide.
So this is the Fannie Mae and Freddie Mac guidelines for condominiums and co-ops. That became effective in September of 2023. It applies to condos, co-ops, and multifamily with 5 or more attached units. And just a background, Fannie Mae and Freddie Mac are government-sponsored entities known as GSEs. They buy about 70% of the mortgages so that mortgage companies can keep making mortgages. So if an association is deemed ineligible by Fannie Mae or Freddie Mac, that means the owners don't have access to 70% of the mortgage market, and it can affect homeowners' values. So these guidelines came out because there's an aging infrastructure, there's structural problems, and more than half of the condos out there are more than 30 years old, and Fannie Mae and Freddie Mac are seeing significant deterioration if they're not well maintained. So they're seeing underfunding of reserves and a lack of political will on boards to address critical repair issues. So when refinancing or they're selling a unit, the lenders will be asking for certain documentation. It's increased since September 2023. They'll be asking for insurance policies, budgets, financial reports, reserve studies, documentation on special assessments, documentation regarding current litigation and alternative dispute resolution, and also building inspection reports for the past 3 years. So the bottom line is that for Fannie Mae and Freddie loans, the project can be deemed ineligible for 4 main reasons. That the project currently needs critical repairs. We're not talking about, routine, roof repairs and so forth, but critical repairs. There's an current evacuation order due to unsafe conditions. There's unfunded repairs totaling more than $10,000 per unit, or the property insurance coverage is not full replacement value. Full replacement value does not include depreciation. So we know these questions by lenders may become overwhelming, but you should consult with your legal counsel on how to phrase and answer the questions to reduce exposure to liability. That's on the guidelines.
Yeah. Okay, this is going to create a huge burden on associations, especially small to mid-size. Large ones that have enough capacity and depth to handle the stuff, they can do it, but this is going to be really burdensome on, I mean, Fannie Mae and Freddie Mac, their intentions are good, but man, this is going to be a problem. And if they can't get their paperwork together, or they don't submit it correctly, they become ineligible, basically blacklisted. Their funding levels are going to drop significantly, the ability to get funding. And we're going to see, I think it's going to have a negative impact on the industry. Overall, they're looking for a positive one, which is to make them safe. But this is going to be a problem to respond to this stuff. So we'll probably do more in a newsletter or maybe another webinar in how to handle these things. Let's go to the next slide.
Yeah, so this one's AB 1572, and I feel like this bill kind of flew under the radar. I didn't really hear a lot of people talking about it, but it has widespread implications for common interest developments. So this bill actually amends a code that I didn't think as a community association attorney I would ever have to know, which is the water code. But here we are. We now are going to be dealing with the water code because it adds sections to the California Water Code. It also amends certain sections of the water code. And this bill is going to be prohibiting the use of potable water to irrigate non-functional turf on multifamily residential properties. And the bill and the statute specifically says common interest developments. The bill was brought because there's an urgent need for additional efforts to reduce unnecessary water use in urban areas. A large portion of California's treated drinking water is used to irrigate urban landscapes. Without drought restrictions, roughly half of all publicly supplied water is used outdoors, primarily for landscape irrigation. So this bill was brought to help communities save water and money and transition to sustainable alternatives. So under this bill, for common interest developments that have turf and that are irrigating it with potable water, you will not be able to irrigate your non-functional turf areas with potable water as of January 1, 2029. Additionally, for common interest developments with more than 5,000 square feet of irrigated areas, you're going to need to certify to the State Water Board that you are complying with this bill starting on June 30th, 2030, and every 3 years thereafter until through 2039. So the big questions I know you're all wondering is, well, what is non-functional turf? How do we know if we have non-functional turf that's going to need to be irrigated with non-potable water? Well, the new statute defines non-functional turf as any turf that is not functional turf. Well, that's helpful. So now we need to figure out what is functional turf. And functional turf is defined as ground cover surface of turf located in a recreational use area or community space. Turf enclosed by fencing or other barriers to permanently preclude human access for recreation or assembly is not functional turf. So under this definition, I think what's going to be really helpful for associations to figure out if some of their turf areas are functional or non-functional is to look at the definition of community space and recreational use areas. Community space means an area designated by the property owner to accommodate human foot traffic for civic, ceremonial, or other community events or social gatherings. Recreational use areas are areas designated by a property owner or government agency to accommodate human foot traffic for recreation, including but not limited to sports fields, golf courses, playgrounds, picnic grounds, or pet exercise areas. So I have a feeling that a lot of community associations with large green belts of turf, we might be seeing a lot more poop bag dispensers in those areas because they're going to be deemed pet exercise areas, or other indications that it's some kind of recreational use area. The statute does have an exemption that the use of potable water is not going to be prohibited to the extent necessary to ensure the health of trees and other perennial non-turf plantings. So if you do have trees or perennial non-turf plantings in areas that are irrigated, it might even be turf areas that are irrigated with potable water, you might be able to continue to irrigate with potable water after January 1, 2029. But what's the takeaway for this? The takeaway is, again, I don't think this bill was talked about a lot, but it has potentially really significant impacts for community associations, especially ones with turf areas. So the takeaway is you need to start consulting with your legal counsel and your landscapers as far as what turf areas may be deemed non-functional and might be subject to this bill, and might have to be irrigated after January 1, 2029 with non-potable water. So don't wait. It's kind of like the balcony bill. Don't wait until December 31st of 2028 to figure out if you needed to convert your turf area irrigation or not.
I think eventually, I mean, what they're after is the reduced water, usage. And a lot of associations probably have areas they can convert using artificial turf or drought tolerant plants and get rid of the real turf so they can reduce their water consumption. So this is something, like you said, that they need to talk to their landscapers and figure out what they can start converting and reducing their water consumption. Let's go to the next slide.
Okay, this is me again. SB 71. This is pretty simple. It's just increasing the small claims limits to generally to $6,250 for actions brought in small claims court, and to $12,500 if brought by a natural person, which is basically a real live human being as opposed to a corporation or a trust or the like. And that's important for our associations because we are associations or corporations and not natural people. So if you're going to bring in action in small claims court to recover delinquent assessment or something else, you have still the smaller limit of $6,250 for those kind of actions. But your owners who are trying to recover against you can go up to $12,500. And the statute also increases limited civil cases to $35,000 for the amount in controversy for those type of actions.
Okay, let's go to the next slide.
Okay,
Corporate
this
transparency.
the Corporate Transparency Act. So there's kind of a lot to this, and I'll try and get through it as quick as possible. But so the Corporate Transparency Act, it's governed by the Financial Crimes Enforcement Network. And what they've done is instituted this reporting rule, which requires beneficial owners of certain companies called reporting companies to report information, personal information about those beneficial owners to the federal government. So this is the Financial Crimes Enforcement Network is a department of the U.S. Treasury. The overall goal of this rule is probably a good thing for the country, not necessarily for associations. But what they're trying to do is track suspicious financial activity, track and prevent money laundering and terrorist financing. So, shell corporations, things like that. It applies to corporations, LLCs, and in any company or entity that is formed by filing a document with the Secretary of State. So that could be more than just corporations and LLCs. It goes into effect January 1st, 2024. However, existing companies, they'll only be affected January 1st, 2025. That's when you'll have to start complying. And it applies to corporations with less than 5 million in assets. Okay, so that's one of the exceptions. So there's 23 exemptions from this reporting rule, and large companies is one of those exceptions. So that would be a company that has more than 20 full-time employees and more than $5 million in assets or sales. In addition to large companies, there's several other types of entities that are exempted: banks, credit unions, securities brokerage firms, insurance companies, accounting firms, inactive companies, not law firms, unfortunately. Tax exempt companies that are organized under 501c of the Internal Revenue Code, those would also be exempted. That would be like a charity, a religious organization. So most HOAs are not a 501c company. Some of them might be, but most are not. So most HOAs are going to fall under as a reporting company and have to comply with this rule. So the next thing to look at is who would be a beneficial owner. A beneficial owner is somebody that exercises substantial control over the company, or somebody that owns or controls at least 25% of the ownership interest of the company. So specific to HOAs, that would most likely be the directors, the board, because the board exercises substantial control over the company. Substantial control is defined as or includes a senior officer, such as a president, vice president, secretary, somebody that has appointment or removal authority, or an important decision maker that directs, determines, or has substantial influence over important decisions. So that's going to be the board. There are some exceptions to people that don't have to or would not be a beneficial owner. And that would be somebody that's a minor, an employee of the company, or somebody that's just acting on behalf of an owner, like an agent. So what information must be reported? The business name. So that would be the association's legal name, address, and then the full name of each beneficial owner, which would be the directors. So their full name, their birth date, their home address, and the identification number and a photo of like a driver's license or a passport. So that's the information that has to be reported about each person. And then if there's any changes to that, a new board member comes in, a new address, something like that, a change has to be reported within 30 days. So the way this is all reported is there's going to be an online system for it. It's not up yet, but it'll all be reported online. And then, of course, what happens if you don't comply? Civil penalties up to $500 a day, criminal penalties up to $10,000, or jail time. So there's some pretty stiff penalties for not complying. And once again, we believe that associations are not intended to fall under this reporting rule, although right now it looks like they are. CAI is working to try and get HOAs exempted from it. And we have about a year to do that, since we won't have to actually start reporting until January 1st of 2025. So
I can tell you, I don't like this act at all. It's really intrusive.
Yes.
And the penalties are significant. Right now, it applies to associations. CAI, I hope they are successful in getting HOAs exempted from this. But who in their right mind wants to be on these boards? I mean, you have to report your name, your birth date, your home address, driver's license or passport to the government, and then hope they don't get hacked and it gets out into the black web. And you're obligated, to be reporting this, just like you report already to the Secretary of State. You're filing forms there, different forms, and now you got to be filing with the federal government. And substantial control, I could argue that it's the management company that has substantial control, because they're looking at the money. They want to know where the money's going and who's dealing with the money, the management companies. So this is, I just don't like this act at all. But right now we're stuck with it. And so I'm sure there's going to be more coming out from CAI as we move forward on what's going to.
Yeah, I mean, the purpose of the act is good, because it is trying to, track really serious issues, money laundering, terrorist financing, things like that. The problem is that it's like a lot of things, it's a one size fits all, and it doesn't actually fit for associations.
Right.
So,
You know, how many associations are involved in terrorist activities? Well,
right.
I suppose some owners would consider that their HOAs are terrorist organizations, but they're
Yeah,
not.
that's not the right question. I think money laundering might be the better question. How many HOAs
Yes.
are money laundering? But yeah, and I have seen some questions. People are asking for the statutes that we've talked about. When are they effective? When are they going into effect? So all the statutes, the state statutes we talked about, they will be effective January 1, 2024.
Right.
So the small claims limit, that will change as of January 1, 2024.
January 1.
Some of the statutes, like the one I talked about, the irrigation, is you don't have to comply until a later date, but the statute will be effective as of January 1.
Right. Okay, let's go to the next slide.
Okay, this is me again. So this is a case that was decided I believe it was this year. LNSU number 1, which is an association, or I'm sorry, they're an owner, versus Alta Del Mar Coastal Collection Community Association. So this is a good one. We like the holding here. You know, at least it provided information that is going to be very useful to us. So the case came about. 2 homeowners filed suit against their association for violations of the Open Meeting Act, alleging that the association violated the act by taking action in executive session that should have been taken in open session, failing to prepare minutes, and discussing association business in emails without providing notice and without taking minutes. So the main takeaway from this case is that directors are allowed to discuss business by email in between meetings. This is sort of a different direction than where we were before this case came down. The appellate court held that board meetings are defined as an in-person gathering, which is important, an in-person gathering of a quorum of directors for the purpose of talking about and taking action on association business. So the important things are there that it's an in-person gathering and that they're talking about and taking action on association business. So the court said that since the directors in this case were not in person and they weren't all together and they were not making any decisions, the emails did not violate the Open Meeting Act. So generally, the board members of this association were emailing back and forth about association business, different things. The plaintiffs were also board members, and they were also participating in the emails. So the code section that the court is interpreting here is 4090, 4090A. And the question is, were the board members' email exchanges, were they considered a board meeting under the act? So what the court did was looked at that code section and the ordinary and usual meaning of those words in the code section. And what they decided was that that the legislature intended it to mean a traditional meeting where the directors are in the same room, at the same time, same physical location, not emails that are sent through cyberspace, received at different times, responded to at different times from different locations. So that's the main takeaway. Another thing that the court sort of clarified is that unanimous consent is needed to hold an emergency meeting via email. So there's always been some confusion about this, but the court made it clear that the decision to hold the meeting must be unanimous, but any decisions made at that meeting do not have to be unanimous. So this clears up a lot of confusion. Another takeaway, I don't know if this is on our slide, but attorney's fees were originally awarded to the association by the trial court, and then that decision was reversed. So the association moved for an award of almost $500,000 in attorney's fees, $409,000, claiming that this lawsuit was at least partly to enforce the governing documents. So there's a code that 5975 that states if you're bringing an action to enforce the governing documents and you're the prevailing party, then the court could award you attorney's fees. So the court looked at that and stated that in order to determine whether the action was to enforce the governing documents, they look at the allegations in the complaint. And in this case, the complaint didn't ask for enforcement of the governing documents, had one citation to the governing documents, didn't attach the governing documents. Really what they were doing was enforcing the Open Meeting Act. So they reversed that and did not award attorney's fees to the association.
Okay, and the attorney's fees are part of law firms, not so much for the members necessarily or managers. I think what caught everybody's attention was the emailing between meetings. And this doesn't affect, the city, county, or state because under the Brown Act. This just affects homeowner associations, and it's okay. And actually, it's good because you're dealing with volunteers, and they don't have time necessarily to get up to speed. Reading materials, management companies sometimes have difficulty getting everything to them in time. So they're looking at stuff sometimes for the first time at the meeting. So it actually helps them to move business along if they can at least talk about it between the meeting and then have a full discussion at the meeting and make their decisions there. So this hopefully will stay in place, not get changed because it actually benefits associations. So let's go to the next slide.
Well, wait, Adrian, can we, I just wanted to say we have, these new all Zoom meetings, right? And I think those count as in-person gatherings under the corporation's code. So for purposes of that, so I want to clarify that.
Right. Yeah. If they all get on a Zoom call together, they're having a meeting because it's considered in person. So yeah, I'm glad you brought that up. Okay, let's go to the next slide.
Okay, so I'm going to talk about the Lake Lindero versus Barone or Baroni. Not sure how to say that name there, but I'm going to say Barone. And this case it's probably more interesting to us as the lawyers, but it's still good for you all as board members and managers to know what this case decided. So in this situation, the association got served with a petition to recall the board. The petition was signed by at least 5% of the members, which under the corporation's code is just 5% of the members can call for a special meeting to recall the board. So that's what happened here. Well, the existing board, when they got the petition, they didn't do anything about it. They didn't call the meeting. You have 20 days to notice the meeting and go through with the recall election. Well, the board didn't do that. And so the corporation's code allows the petitioners, the people who are bringing the petition, to go ahead and hold the meeting. And that's what they did. So the people who brought the petition hired an inspector of elections. I don't think they hired, I think they used the League of Women Voters, but they got an inspector of elections. They sent out ballots and all the notices complied with the Davis-Stirling Act, and the recall was successful. Well, the existing board member, and I believe Mr. Baroni was actually the CEO of the association, they refused to recognize these petitioners who had been successful in the recall. They refused to recognize them as the new board members. So they brought an action under the corporation's code 7616, seeking a determination that they were the board, that this recall was valid. So what was, Adrian, can you mute yourself? I think you're causing an echo maybe. But anyway, what was the issue? One of the things that they contended in this case, or the defense, actually the defendant contended, was that the vote for the recall was not done in accordance with the bylaws. So the bylaws for this corporation, and the corporation was large, it was over 50, it was 459 separate interests. The bylaws said that in order to recall the board, you needed a vote of approval of a majority of the total number of members of the association. So 230 out of the 459 had to vote in favor of the recall. Well, the plaintiffs said, well, no, if you look at the statutes under the corporations code, and there are 3 different statutes that you have to, it's kind of a circular path that the California Corporations Code takes you through. But when you look at these 3 code sections, the conclusion is that regardless of what the bylaws say, in a corporation of 50 or more separate interests, members, that the approval to recall the board of directors is really a majority of a quorum. It's not a majority of the total. And so here they said, we met the majority of the quorum requirement. That was enough, even though the bylaws required a higher amount, which is a majority of the total members. And the court agreed. The court looked at those 3 different corporations code sections. They agreed with these petitioners and said, yes, it doesn't matter if the bylaws have a higher threshold for a recall vote. It is a majority of a quorum where your corporation is more than 50 members. If you are a smaller association, if you're under 50, then it is a majority of the total. But for 50 or more, it's a majority of a quorum. So that was that case.
Okay. Next case.
Okay, this is mine again. This is Takaguchi versus Venetian Condominiums Maintenance Corporation. And this is about elections and quorum again. So it involved really kind of shenanigans by these owners who owned multiple units and controlled the board. It was a very small board. So 2 of them controlled the 3-member board, and they just completely failed to hold elections. And eventually people got fed up, and they managed to have an election be held here. And so then more shenanigans ensued. Essentially, they needed a certain number of ballots to be returned, and 188 to meet quorum, and they only had 166 ballots returned. And so basically they didn't even have the inspector show up at the meeting, and they were just gonna, because they assumed that they were going to have to adjourn the meeting, and which would have resulted in a reduced quorum, and then recount at a later date and also accept more ballots during that time. But what they failed to take into account was that additional members attended that actual ballot tabulation meeting via Zoom, and they should have been counted towards the quorum of the meeting. I think we get really used to saying, you know, oh, only the ballots count as the quorum for our ballot tabulation meetings, but it is actually everybody who shows up at the meeting, in addition to those who submitted ballots and didn't attend in person. And so with the additional people, they would have reached the 188 that they needed to establish quorum and to open the ballots. And the court affirmed that the ballot should have been counted at that meeting. It should not have been adjourned, and they should not have had to accept any additional ballots at that time. And because enough people had been present at the meeting, whether by ballot or in person, to constitute a quorum. And so the remedy that the court ordered was a new meeting to count the 166 ballots that had been returned, because that was enough to have a valid election and to have the results of that election be to be valid with the association.
Okay, let's go to the next slide. Fairleigh Hayes versus White Sails. This involves parking, which associations run into from time to time. Handicapped person wants to have their own parking space close to the elevators. That's what happened here. The owners had 2 parking spaces already. One was handicapped, and he wanted it close to the elevator. He made a demand on the association, and the developer. There used to be a handicapped space in the garage and the parking structure. And what did the developer do? He deeded it to somebody, probably sold it to one of the owners who was not handicapped. And I've run into that a number of times over the years. Developers tend to do that. And so there were no spaces available. The association said, you can have one outside, but we can't give you anything inside because they're deeded. So we don't have any authority. So they went to arbitration The arbitrator, retired judge, agreed with the association. They didn't have authority to give them a space in the parking structure, and he could have one outside, but he wanted it to be permanently assigned to him. So they said, yes, you can do it, but you have to give up one of your 2 spaces in the parking structure. Well, he didn't like the arbitrator's decision on that, so he went to court. Trial court agreed with the association and the arbitrator, and then ordered insurance fees. Well, he didn't like that, so went to court of appeal. And the court of appeal came out with the same supporting trial court and awarding attorney's fees, basically saying the association doesn't have authority to move deeded spaces around. And if you want a space permanently assigned to you outside, you've got to give up one of your other spaces. So this is an unpublished decision, but it shows that how we should be handling these kinds of things. So if you've got these requests, anything ADA related, you generally want to talk to your legal counsel, and they need to look at this particular situation and advise the board, because you've got organizations out there that will represent these owners for free. And so they'll go straight into court. You want to avoid getting into court if you can, and make sure that you're handling these kinds of requests properly. So this was, I think, generally a good outcome for the association and for the industry. Okay, let's go to the next slide.
And I want to clarify, because there was a question. So the first 3 cases we talked about, those are published decisions. That means they are law. Right. They can be cited and relied upon, and they are binding on the courts in California, on the lower courts in California. Unpublished decisions means they are not binding law. So they cannot be cited. They are not to be relied upon. But we picked some of the unpublished cases this year to talk about because we feel that the principles that were addressed in those cases are still important to understand how a court of appeal addressed it.
Right, I agree. Okay, who has Lindero Ranch?
That's me, Melissa. Yeah, the unpublished decisions are good at showing trends too, and thinking, and often we find published decisions later that address the same thing. So this is another unpublished decision, but I think a useful one nonetheless. So the association had sued Tinsley, an owner, about architectural violations. They were pretty, I wouldn't say minor, but fairly minor. It was a large tarp that had been erected adjacent to the house, and failure to replace a couple of trees that they'd removed from the yard. So they went to court, and they prevailed after an 8-day trial on these issues, 8 days. And it took apparently 2,700 attorney hours by 11 different attorneys to prevail on this case. And so after they had won, they made a request to recover their attorney fees. The association did on a prevailing party attorney fee kind of claim. They sought to recover over $500,000 for this case, and the court said that the fees were manifestly excessive, and they remanded to the trial court for a more reasonable fee award to be made. And the takeaway here is that the right to attorney fees for prevailing parties is not a blank check, and even if you win at trial, your fees still have to be reasonable if you're going to recover them. All right.
Okay, so the next slide.
Okay, this is another unpublished case. It's involving a civil harassment restraining order. This involved a small HOA. Manrot is a 35-year-old married woman with small kids, and Alello is a 55-year-old man, and he would film Manrot since they moved in the development. He would position his chair and wait for her to walk by with her infant. He started recording with a cell phone, and then he invested in a body camera. He also recorded Manrot's husband as he left for work to see if he could catch him speeding. He also went to the front door and filmed through the glass a few inches away, and also filmed their backyard. Manrot felt extreme levels of distress and anxiety over the filming of her and her family, and as he was waiting for them to leave the house and come back to the house. Alello was filming to catch violations by Manrot and admitted so in court. He said, "If I don't film these people and then provide the HOA with video evidence, they won't even consider my complaints." He tried to justify that he was just trying to enforce the rules, and not just Manrot, but also looking at other residents as well. And so the lower court, the civil harassment restraining order was issued, and it prohibited photographing and videotaping of Manrot and her family, and unless there was an active violation of the law or the CC&Rs occurring. But he couldn't lurk about and anticipate the violations. So he appealed and said, this is for a legitimate purpose. And the court disagreed and affirmed the ruling and found his conduct harassing and not protected by free speech. So the takeaway is essentially that you can't just be waiting around, lying in wait for someone to violate the CC&Rs, but it is legitimate if if it's an active violation and you need it for evidence.
Adrian, I think you're causing an echo again.
I'm not sure coming from my end, but this is, for most boards, they rely on members to tell them, if they see a violation. If you see something, you say something, but this went to extreme. And you can't have owners doing this, stalking people and trying to find something. If there's an obvious violation, of course you report it to the board. But he was looking for stuff, trying to find and track people down, and especially his neighbor here. And the court, I think, rightly decided this was stalking and harassing. So it's something that you can remind owners that go to extremes, that they might get sued and a restraining order brought against them. So I thought this was a good case. Laurie, did you want to say something about it?
Yeah, I wanted to bring the point that this was the neighboring owner who brought this harassment claim, not the association. So we get that a lot. We get a lot of the associations wanting to bring these actions on behalf of the homeowners who are in this situation. And it's just for the association's ability to do that is very limited. And it is the homeowner who is being stalked in this situation is in a much better position to get that restraining order than the association on the owner's behalf.
Okay, let's go to the next slide.
I think that's it.
Okay, we get questions about, from people who want to really look at this and read the cases and read the bills. We have them all posted on the website. So you can see the tab there that says new laws. If you click on that, let's go to the next slide. It will open up into, we have them listed by year. So we have them going from current 2023 all the way back. And it shows the bills with links to them. You could click on it, go straight to the bill, read the bill. If scrolling down further, we've got the cases with links to the cases. So you can actually click on them and read the cases if you want to do additional research or you're just interested in more details about the case. So this is just a valuable resource that we posted for everybody. Let's go to the next one. I think it's now Q&A. So, and I think Miranda or Rachel, one of you were keeping track of questions.
Yes, hello. So we are actually at 1 o'clock. Did you guys want to go over and answer a few, or did we want to go with our original?
Let's go through and answer them, and we'll.
Your video is breaking. Your audio, excuse me, Adrian, is breaking up.
Okay, go ahead, Miranda.
All right. Well, thank you to our speakers. We've been recording your questions via the chat and QA box. And if there are any questions we cannot get to today, please look at our next newsletter. If you do not already subscribe to our newsletter, please make sure to check it out. We will post a link in the chat right now. Unless directly asked by a speaker to provide clarification on your question, please remain muted so we can get through as many questions as possible. Can you confirm executive sessions can be held in via Zoom or email?
I did confirm that, yes.
Does a physical location for ballot counting have to be within the community or near the community?
It'll depend on what's in their bylaws.
Yeah, the statute doesn't say anything, doesn't address that issue.
But the bylaws usually do, especially for a membership meeting, they usually say where the location of that membership meeting needs to be.
Right.
Like, usually it's in the county, reasonable proximity to the development. Those are that's the language you're going to see.
Can you define what individual notice means? Maybe provide an example.
You could go on our website, look up the statute. But individual notice is generally going to be first class mail or email if the owner has consented to receiving email. There's other methods too that it's defined in the Davis-Stirling Act.
Does the 20% assessment law supersede our governing documents limits both lower or higher?
Well, if you've got one that's lower, we have associations that are at 15%. So if their bylaws allow them to drop down to 15%, then of course they're going to go to 15 rather than 20.
Yeah, I actually think the statute though says, even if the bylaws say that the board is limited or the board could do less, they could do more. From what they can go up to 20% each year without a vote of the membership, and they can impose a special assessment of 5% of the budget without a vote of the membership. If that's
regardless of what the bylaws say.
Regardless of what the CC&R say, it's usually in the CC&Rs.
Right. Okay.
Your quorum is in place at 25%. Will this law override governing docs and put in place 20%?
It can.
Yes.
If you don't meet the 25%, if the question is when we don't meet our quorum, it can reduce to 25%. Could we then use the law to actually reduce to 20%? The answer is yes.
If we have a 25% rule, do we go by AB 1458?
So if the 25% is for the initial meeting, if your quorum is 25% initially, you go with that. But It's a reduction. It's if you don't meet the quorum. What the purpose of this law, the reason why this law came about is there are a number of associations where their bylaws have a quorum requirement, and then if they can't meet the quorum requirement when they adjourn the meeting, the quorum doesn't reduce down. That was the purpose of this bill, was to allow a mechanism for those associations to not have to continue to just adjourn their annual elections and not have the quorum reduced. So that's really what the purpose of the law is.
Thank you. Please talk about how to properly conduct and record a roll call vote.
Melissa
roll
Ward,
call votes, you just ask.
Exactly.
You just ask each director.
Yeah, by name.
So each director's name. So probably the secretary, the recording secretary, the manager would say each director's name out loud, and then they would say how they vote.
Yes or no. Yeah.
And then you would go through each director.
And the minutes would reflect that. So the minutes would reflect, Melissa Ward, aye. Alison Greiner, nay.
Virtual meetings where ballots are to be opened by an inspector of elections. Can the ballot opening process take place virtually, or must it take place in person?
Allison, why don't you take that one?
Yeah, no, we still think that
the debate on that
elections tabulating the ballots can be done virtually. There's nothing in the statute that says otherwise. So they can be virtual, but you just still have to provide a physical location in addition to the virtual option for that meeting.
So the physical location is really for the members to attend. We will say the statute isn't clear on that point. So, that's our interpretation, is that we think the inspectors of election could still not be there in person tabulating the ballots. The statute requires the members to be able to witness the tabulation of the ballots. So as long as they can come to a physical location where the broadcasting of that tabulation can be done and the members can witness it, we believe that's going to comply with the statute. It's arguably, it's not clear, and others could have different interpretations.
Yeah, and you definitely need a big screen. You can't just have a little teeny laptop there, and you want to make sure to zoom back enough that people can actually see the counting by the inspector, not just their face. So, we wanted people to be able to see it.
When are electronic voting methods allowed?
Not yet.
Well, not for the type of elections that require the double envelope secret ballot. If it's not one of those 4 types of elections, then we've always been able to use other types of voting.
Right. All other corporations in the state can do them electronically, except associations.
All right. We do not have term limits. What are the proper steps or language to make this happen?
Amending the bylaws. And I wonder, if it's not in the bylaws, Laurie, what do you think? Can they do it just in their election rules?
I think it's going to be risky to do it in the election rules and not do it in the bylaws. I mean, there is a Friars Village versus Hansing case that talked about qualification back before the qualifications weren't so limited, that you could have qualifications in the election rules that weren't in the bylaws. So we might be able to use that for term limits, but I think it's going to be much safer and a better bet to do it in the bylaws.
I agree. Yeah, and you can have it, typically, and what we do in our bylaws is that you serve 2 terms, and they're basically staggered terms. We set up for directors for associations. So 2-year staggered terms, and then they serve 2 terms and then have to step down for at least a year, unless there's nobody else running for the seat. Then the term limits are waived, because what you don't want is ending up with only 1 director on the board, because everybody's been turned out and there's nobody else willing to run.
Yeah, I think term limits should be used with caution. More and more these days, and especially with the Corporate Transparency Act, I think you're going to have a hard time getting people to agree to serve as directors. So limiting their terms is only going to just tie your hands more in getting directors. But
So the next one has to do with ADUs. How will this affect parking and other maintenance needs of the association?
It's a mess.
yeah, I don't think AB 1033 really affects it. I mean, owners have the right to build ADUs and junior accessory dwelling units the same as they do now. So that bill doesn't really affect that. And those were a lot of the issues that we talked about when the ADU law came out a few years ago, was the stress on infrastructure, that on communities that were designed for a certain number of occupants. It's now, increasing that occupancy, and the stress on infrastructure, parking, all of those things. AB 1033 didn't change that.
Yeah, and I agree. It's ADUs themselves will stress the infrastructure. It's a conversion to condos that are going to create all kinds of questions about, what do you have to amend your CC&Rs now to add them as a member? Do they get voting rights? And we think that should all be avoided by amending CC&Rs. Today they don't get into that, and it's going to require a majority membership vote to allow the conversion to take place.
You were breaking up a little bit there, but I think the takeaway is that AB 1033 is going to require some kind of amendments to your governing documents, we think. But you're going to need to consult with your legal counsel and get their recommendation.
Right.
Where can we find the Fannie Mae guidelines?
Jason.
You can go to, it's pretty much, you can Google search Fannie Mae guidelines and it'll take you to it. But basically it's the regulation agency has the guidelines on their website.
And we will post them on our website. So you can go there and click on the link and then go straight to the guidelines.
What does the new lender guidelines mean for management and HOA compliance and cost of providing?
I just think that all the documents, those several documents, the budgets, the reserve study, and information about special assessments and so forth. They should have it handy and ready, because essentially these lenders are going to be asking these questions for all these documents, and just have them ready and available.
Lender guidelines updated for if the HOA tries to get loans, or for people trying to buy a condo in an HOA.
It's for the people, it's for individual owners who are trying to get loans. So if the project's deemed ineligible, all the owners would be ineligible for obtaining loans through Fannie Mae or Freddie Mac, which again is 70% of the loan market. So it's not for HOAs getting loans, it's for the individuals.
Okay, and do lender guideline changes apply to PUDs?
To PA applies to
Yes.
any with attachments of 5 or more units. So that's the where the guidelines apply to.
So you could have townhouse plan developments with attached units that it's going to apply to.
If it's 5 or more, yes,
Yeah.
that's my understanding of the guidelines.
ADU/JADU owners are not members. The board can't call them to a hearing. Who would they call?
The lot owner, the owner of the lot in the plan development.
AB 1572, what agency will be enforcing? Question mark, water company, question mark.
Yeah, it is the water company, although the reporting is to the state. Let me just double check, but the reporting is going to be to the state water authority, I believe. Look that up. State water board is where you have to report compliance, but how to get potable water to those irrigated areas is going to be through the local water district. So
Would they have to do underground piping for the community to make that happen? Do you know?
I don't know. Again, you're going to need to consult with the landscapers. And I mean, if it's non-potable water supplied by a water authority, yes, it is. I mean, it comes through a piping system, and they're purple pipes. If anybody has those recycled water pipes, they're purple pipes and things like that. But this is definitely going to need consultation with your local water authority, your landscapers, to figure out how you're going to comply.
Does delivery of, I just read that, Transparency Act, how is this done? Does the government reach out?
No, no, that's one of the problems. No, you have to actively report it yourself. Yeah, there'll be a website to do the reporting on.
Kind of like filing taxes.
Yeah, or a statement of information.
Okay, and then who receives transparency info that the HOA files?
So it's the federal government, and apparently it's going to be very protected and limited. So only government agencies will be able to access that information.
So they say.
It does raise a good question though, like if the association is receiving all that information to report it to the government, what do you do as a manager or a director? What do you do with that information? So I have to say, if you don't have some sort of policy or safe way of keeping data like that, you should shred it and get rid of it once you've done your reporting, so that it's not hanging around your community, so it can't be taken by anybody else. So definitely a problem.
Yeah, and they're not going to reach out. The government's not going to reach out to you unless you fail to file. It's like the taxes. You fail to file, that they may be reaching out. You may be facing penalties.
All right, regarding Corporate Transparency Act, what should we do if an HOA does not have any board members?
What?
That might be a bigger issue than the Corporate Transparency Act.
It stumped me. There's probably some way of reporting. If there's a manager, or there's probably some way of
Yeah, I
contacting them.
think we have to consult with council on that one, and we'll just
Yeah.
hope that CAI comes through with their efforts to
Yes.
facilitate all of the HOAs in the next year. So
Okay, we are 15 minutes over. We should probably stop at this point. And then we'll take the rest of the questions and go through them, group them together and answer them in an upcoming newsletter. So I want to thank everybody for attending and see, if I'm breaking up,
You're
then,
breaking up, right?
Laurie can take from here.
Thank you all for joining us for our legislative update. Hope it was informative, and submit your questions to the newsletter and reading the newsletter. Miranda, if they don't know how to subscribe to the newsletter, what can we tell them?
There was a link put in the chat. You can also go straight on our website, Davis-Stirling.com, and the tab at the top that says newsletters. Click on that, and there's the box right at the top where you can put in your email address. You can also email me and I can add you as well.
All right. Thank you all, and have a great rest of the day.
Thank you.
Thank you, everyone. Thank you, speakers. Thank you, attendees.